Good evening. I want to welcome you all for joining us tonight. We're here tonight to talk about young adult guardianships and how they can be avoided, quite frankly. Going to introduce you to myself. I'm Shirley Ramadani. I am an elder law, estate planning, special needs attorney in Oak Brook. I'm with Piercey and Associates, and we specialize in estate planning. And I specifically specialize in the documents that are important to keep folks out of probate and also out of guardianship court. So I'm going to start with a presentation. During the presentation, if you have questions, go ahead and type them into the chat room. I won't be able to see them while the presentation's up, but as soon as I'm done with the presentation and I take it down, when I get to questions, I'll see those and I will answer them as they come in, okay? So let's get started. Let me share my screen with you. We're gonna go here to our Okay, so again, guardianship of young adult children and how to avoid it. So law is my second career. I came to law, graduated from law school about 15 years ago. I went to law school thinking that I was going to end up writing contracts because I had always worked in corporate American procurement. And while there, I always negotiated contracts and did those sorts of things and was told, you're really good at this, you should go to law school. And so I did. And after about a year of contracting classes, I realized that if I did that for the rest of my life, I was not going to be a happy camper. And by the luck of the draw, I had met and secured housing from one of my professors. She had a 3-room suite over her garage that I rented. I was there for weekends. And she just happened to be the person who ran the elder law clinic for my law school. It was one of the only elder law clinics at the time. And she said to me, come to work for me at the clinic. And I said, oh, I don't want to do that. And she convinced me that it was worth going and taking a look at. And so I started working in the elder law clinic and absolutely fell in love with this area of law. Taking care of the elderly, the minor children with disabilities, minor children with guardianship issues, and just everything that went along with it. And I knew that when I graduated and passed the bar, that what I wanted to do was get into this area of law. So that's how I got here. In doing so, before I was able to drop out of corporate America after passing the bar, I had 4 children home that were last 2 were in college. And so I was writing tuition checks. And so staying with the corporate salary was important and not going off on my own. So during that time, I volunteered for the probate court in Cook County. And what that allowed me to do was to be appointed as guardian ad litem. A guardian ad litem is an attorney who is assigned to a case where someone has filed to become a guardian of another individual, an adult, a child, or some other individual that they say is disabled and needs to have a guardian oversee their life, either both personally or personally and financially, or just personally or just financially. And a guardian ad litem is appointed to determine the facts for the court, because the judge can't go out and investigate themselves and ask the questions that a guardian ad litem can. And so I started volunteering my vacation time to become a guardian ad litem for the Cook County Court, and was appointed for 4 years exclusively as guardian ad litem. During that time, I built a reputation with the judges of being a very caring and loving advocate for the respondents, the persons who are being asked to be adjudicated disabled. And therefore, once I went out on my own, I continued to get the appointments. And then I started getting appointments not only for the guardian ad litem, but also for appointed counsel. So I would say about 5 years ago, I saw an uptick, this 55 years ago, where all of a sudden I was getting appointed to be guardian ad litem for young adults. I'm talking about people who are 18 to 23 years old. In that first year, I was appointed 3 times for young adults who had had catastrophic events or illnesses occur or mental health issues occur when they went away to school. And this really affected me in that I saw what it put the family through. It's one thing to get a guardian for an elder adult to ensure that the care that they need and everything, but to put a family in the situation where they have a young adult child that now has to be adjudicated as a disabled individual and has to be monitored by the courts for the rest of their natural life is quite overwhelming, quite expensive, and very, very burdensome. And because of that, I started thinking that in order to alleviate this, it would be so important to educate the people on the need for young adults having powers of attorney and an estate plan as they get ready to leave home and go away to college or go to work. As soon as you turn 18, you should look at an estate plan that includes, number one and foremost, your powers of attorney. Our agenda tonight is first of all, we're going to look at why do I need an estate plan? And we're also going to go over the basics of what an estate plan is. We're going to look at basic estate planning documents, and that'll include the powers of attorney. There are 3 different types: wills, trusts, and other specialty documents. We're going to talk about the importance of powers of attorney because, as I said, that's why I'm here tonight, is to educate you on the importance of powers of attorney for young adults. And we're going to talk about an agent's role. An agent is the person that you select to answer for you, and how you would go about selecting an agent. So why do young adults need an estate plan? Well, it comes down to the fact that life is full of surprises and we cannot always control what those surprises are, and they're not always pleasant. Some of them are life-changing and catastrophic. And because of that, as soon as you become an adult, you need to consider putting your estate plan in place in order to protect not only you, but your family from years and years of judicial oversight and cost and restrictions. Basic estate planning documents include powers of attorney. There are 3 types of powers of attorney that I'm going to go into greater depth about in a little bit, but just overall, to begin with, the healthcare power of attorney. And in Illinois, it's called property power of attorney, durable property power of attorney for finance. And then there is a mental health directive, which is your healthcare power, your mental health care power of attorney. There are generally 2 types of wills. We're not going to go into detail on the wills or the trust. I'm just giving you an overview of estate planning documents. You have what is a standalone will, a will that simply says, this is who I am, this is who I want to handle things, this is how I want them handled, and it's done. And as long as you're an individual that doesn't own real estate, and your assets are not over $100,000, a standalone will is more than sufficient. You do have to go through probate, but it's a pretty easy process as long as there's no objections and there's no one saying that the will is not valid. The other more common type of will is a pour-over will. And what that is a will that says, I am who I am, I'm appointing this person, not only to be my executor, but to be my trustee. And everything I own is going into my trust upon my death. And then in that regard, that keeps you out of probate, because as long as all of your assets, or assets is under $100,000, and all of your real estate have gone into your trust, then it does not have to go through probate unless someone objects. Of course, there's always that you've got to, the legal language at the bottom, except for. And then there are trusts. There are many kinds of trusts. The most basic are the revocable trust and an irrevocable trust, special needs trust. And then there are other documents that are very commonly referred to. TODI, which is a transfer on death instrument, which transfers title to various property and assets to an individual that you name. Paid on death, which is a financial accounts that you can indicate who the beneficiary is. And then there are also designated beneficiaries. Designated beneficiaries are where you opt during your lifetime to select a person and notify your financial institution of that designation, and that person will then get that asset upon your death. Okay, so let's talk about the importance of powers of attorney. I believe in my heart of hearts that these powers of attorney are the most important documents that a young adult, a living adult, an adult of any age should have, and have active, current, and in place. Powers of attorney are important because if you don't have one, you can't protect yourself when you can't act for yourself. Your wishes may not be followed. If you don't have a power of attorney and a decision has to be made either for your health care or for finances, you would have to go to court and get a guardianship. So then you've got judicial interaction that now will oversee all of the transactions and all of the care questions that have to be answered for that individual moving forward until that individual dies, or until that individual is able to become a reinstated competent adult. Now, people will say, well, why can't my spouse or my parents be my answer for me? And the problem is, once you become an adult, your parents can't answer for you unless you've designated that they are your agent and you want them to answer for you. As far as your spouse is concerned, your spouse is able to answer for you to a certain level. But if there is no written directive in regards to end of life or treatment that you want, and your spouse becomes adverse to an interested party, a sibling, a parent, or a child even, then that can cause a court action that would then bring everybody in to have to deal with that. The reason that young adults are having to consider, of course, there's illness, and we can't talk about illness without talking about the global pandemic of COVID-19. That's in everyone's face. And right now, in the last 2 months, the largest growing number of positive cases comes from colleges across America. The next is accidents. And that was one of the things that I saw in the young adult guardianships that I was involved in, traumatic brain injuries that occurred either because of an automobile or because of a sports injury. There's also falls. And let's be honest, there's drug and alcohol abuse, binge drinking, experimentation with drugs that causes catastrophic events in young adult lives that now they're not able to act for themselves or speak for themselves, since somebody is put into the position of having to do that. And if you don't have a power of attorney in effect before this occurs, it can't be done after it occurs, it has to go through guardianship. The other issue that I have seen an uptick in is mental health issues. There is a mental health directive, as I said, as a mental health power of attorney. That document allows your, mental health issues, which includes depression, suicide, paranoid schizophrenia. Paranoid schizophrenia is an infliction that generally comes on with young adults between 25 and 35 years old. Of course, it can happen later in life, but the most severe cases have proven to be during that 25 to 35 year age group where it hits. So moving on. Okay. So let's talk about the power of attorney for healthcare. So without a power of attorney for healthcare, which would include your HIPAA release, and I'll explain that a little bit here, but the power of attorney for healthcare, without one, your healthcare providers are prohibited by law from providing medical information to anyone. So their hands are tied and they're limited in what they can share. That's not to say that they're not going to take life-saving action, but it is to say that if decisions have to be made in regards to ventilators or different types of things such as that, those are things that they're going to be very cautious about making decisions about, especially if there are conflicting opinions amongst the parties that are there that care for this person. A person without a health care power of attorney could be placed on life support for an extended period. This is your Terry Shivos. This is where Terry's husband and her parents disagreed. And she was on life support for several years because of the court battles that pursued. And the medical costs that would be imposed because of treatment being given and forced upon you that you may not have wished could literally deplete all of your assets. So that's another consideration that you must look at. Now, when you do have a power of attorney for healthcare, you designate an agent. And that person makes all of your decisions on your behalf when you are unable. Now, that doesn't mean that if you get sick and you're still able to communicate, that person could say, no, I disagree with him. I want you to do this. That's not the case. As long as you're capable and able to express your wishes trumps everybody else's. So your power of attorney being in place doesn't mean that somebody has almighty power over you. And in having a healthcare power of attorney, you get to identify the depth of care that you prefer, whether it be just as an example, I have a friend who, no matter what, feels so strongly that she never wants to be intubated. And even if that means that she would lose her life, that she would die if she was not intubated, she is steadfast that she does not want that. And that's your decision. So with a healthcare power of attorney in place, you're able to identify what kind of care you want all the way through your life to the end of your life. You can prevent being held on life support indefinitely, and you get to determine your end of life decisions. Now, HIPAA authorization is a document that is required with the Affordable Care Act that allows healthcare providers not only to provide medical information to those that you designate on the release, but also financial information in regards to your healthcare. As you're aware, or as you may not be aware, the Affordable Care Act requires that doctors have to give you a summary of the cost of treatment that you're going to get, or some idea of what the cost of treatment will be. With this, your agent and the loved ones that you identify, because you don't just name your agent, but you can identify number of people that you are giving access to your medical records. If their name is on the HIPAA release that's been executed and notarized, then they would be able to get your medical records and assist your agent in anything that needs to be handled in regards to your health care. Okay. Let's talk about the powers of attorney for financial decisions. In Illinois, as I mentioned before, in Illinois, it's called the power of attorney for property, durable power of attorney for property. So when you can't make financial decisions for yourself, immediately you have to go for court interaction. And your assets are generally frozen when court interaction is initiated until the court can get their arms and mind around your assets and your needs and what's the most important thing that needs to be taken care of for you. In addition, this would require continued judicial reporting for as long as you are a disabled person. And the guardian that is appointed may not be someone that you would want to be in charge of your finances and to handle everything for you. Guardianship processes can cost anywhere from $5,000 to $10,000 and more if they're contested. So the cost alone of not having a power of attorney in place is astronomical compared to what it would cost to have the power of attorney in place. So with the power of attorney for property, you get to choose the agent that makes financial decisions for you. They are someone who has a legal obligation to act as your fiduciary in your best interest at all times. They're legally bound to do that. There is no judicial action required, therefore there's no cost, there's no delay. As long as the powers of attorney for property have been in place and have been properly disseminated to the proper folks prior to the need, your agent can act immediately. I always suggest strongly to my clients when they execute powers of attorney for property that they take a copy to their bank and they tell their bank this is who they've nominated as their agent. They want them to put it on record and they want it to go through their legal review now while you're competent and while you're able to answer any questions. You want to give a copy to your financial planner and to any financial institution in which you have an account. You want to put them on notice who you have named as your agent. For healthcare, I neglected to mention that, but for healthcare, your healthcare power of attorney, I strongly suggest to all my clients to make sure that they give their attending physician a copy of their power of attorney, who they want their agent to be, that they keep a copy in the glove box of their car. Fire personnel are, first responder personnel are trained to look in your glove box to see if there's a power of attorney so they know who to notify of what's going on. So keep one in your car, give one to your doctor. If you go to a local hospital, give one to your local hospital before the need. The original should be, our firm keeps them in our vault, the originals. If you're dealing with an attorney who doesn't have a secure place to keep them, then the originals, then I would strongly suggest that you keep them either in a safe deposit box at the bank that your agent also has access and a key to get into, or in a safe that is fireproof and waterproof at home that, again, your agent is able to get into and knows where to locate it. An agent for financial decisions, if properly written, if the power of attorney is properly written to include additional powers, would also have the ability to adjust your estate plan documents to conform to changing laws in the future, to ensure that your desires and your wishes are met throughout your life. Without power of attorney for finances in place that had the additional powers, they would not be able to do that. And your power of attorney could, based on changes in the law, become ineffective or become less effective than what you would like them to be. Okay. Uh, Power of attorney for mental health. As I mentioned before, this is the third and newest power of attorney that I have been talking to all of my clients about. It seems as though mental health issues are coming more to the forefront and in light than they have in the past. And in order to help someone who might have an issue, considering having a power of attorney for mental health in place prior to need is strongly recommended. I strongly recommend it for students going away to college. There's a lot of things that go on, loneliness and different things that can cause all sorts of issues. And if a mental health power of attorney is in place, a family will be able to help you, whereas if it's not, they won't be able to step in and ensure that you get the mental health care that you need. And at that point, you may not be able to ask. You may not have the capacity to ask for help yourself. And because of that, then your family would have, there are two areas of court law that they'd have to go through. They would have to go into mental health court and get a mental health guardianship put in place for you, which names a guardian who could make mental health decisions for you. But then because you have a mental health issue, you're considered disabled, and then the Probate Act requires that they go in and get guardianship for you as an individual and financially to handle your affairs in that regard too. So not only are you paying for court for the mental health guardianship, but you would be paying for the probate guardianship as well. If you don't have one in place, the person that the court appoints may not be somebody you want. Again, I have seen this happen over and over and over again, where a person doesn't have anything in place and they have a catastrophic incident in their life and end up being adjudicated disabled. And the person who has come to court to handle the affairs for this person is truly not someone that they would have wanted. And it has caused a lot of family heartache in the instances that I've experienced in court. The cost to appoint a guardian in both the mental health court and in the probate court is extremely significant. And it forces you to be exposed and answer to ongoing court supervision. Now, if you had a mental health power of attorney in place, doesn't mean that the person that you name as your agent can lock you up for the rest of your life. The law is written so that it can protect you while at the same time giving someone the ability to help you. Initially, your agent would be able to have you committed for up to 14 days for observation and treatment. Without this in place, a person can only be held for 72 hours unless they're a threat to themselves or someone else. 72 hours generally is not enough time to get somebody stabilized when they're having a chemical imbalance. They've found that 14 days is about the amount of time that most people need for observation and treatment to get them even, so that everyone can work together moving forward to handle everything appropriately for the individual. With the mental health directive in place, there's no court involvement, there's no judges, there's no lawyers, there's no delay, and of course, greatly reduced in that you're only paying to have the healthcare directive put into place, along with your other powers of attorney. Another key issue that you need to understand about a mental health directive is that your agent does not make decisions for you in a vacuum. Your agent must work with your mental health professional or professionals and both agree on the proper treatment and in a timely manner. This your agent for mental health directive isn't the end decision maker. They must all decisions are made with a mental health professional to ensure that the right treatment and services are obtained for you. Okay, so let's look at how do you select an agent? Now, this is a very important decision. You have to consider the weight and magnitude of the role of the person in which that you're asking to act on your behalf, whether it be healthcare, mental health, or financially. And you have to be sure that the person that you're selecting is someone who you know and believe will follow your wishes, even if they don't necessarily agree with the decisions that you have made for your life. Okay, they need to be somebody that you trust. They need to be someone who you have had conversations with, and that to say to have a conversation with someone seems like an easy thing. However, these are not easy conversations. These are very hard conversations. People do not like talking about when they can't act for themselves or when they may be faced with the fact that they're at the end of their life. And having these very frank and thorough conversations with someone is not an easy thing to do, but it is a necessary thing to do in order to make sure that the person you're selecting for your agent is going to be able to follow your wishes. The person that you select, you need to make sure that they will have the strength to be the advocate that you need them to be when they're opposed, whether they're being opposed by a medical professional, a financial professional, or a mental health professional, or family, or friends. It's happened every way that you can imagine, where an agent has had to stand up against family, friends, doctors, lawyers, candle makers, everyone, to ensure that your wishes are followed because they've had these important conversations with you and they understand the importance of making sure that your wishes are adhered to. The person that you're considering needs to truly understand their legal responsibility, their culpability in regards to the financial matter specifically, because they have a legal duty to act in your best interest and not in their interest in any way, shape, or form, or they can be prosecuted. So they need to understand that. They need to understand that if they have access to your assets and you're not spending them and they need something, they can't use your assets to take care of something they need. Again, they've got to understand what your wishes are and understand that your wishes must be followed. That is the way the law is written. And even if they disagree with what you have asked them to do, because they are your wishes, they must work to make sure that they are followed. And that you have to know that they will fight when others disagree. So now what? What do you do now that you know about basic estate planning documents and the most important ones to a living adult being the powers of attorney? What do you do now? So you understand this, and what you would need to do is you need to call an estate planning attorney and schedule a consultation. Okay. You need to ask yourself who you think you would have in your life that would be a good agent for you. You need to have discussions with that person or persons. Just because you name somebody an agent for your healthcare doesn't mean they have to be an agent for your finances as well. It can be different people. It can be people that you know, trust, and understand who are going to take care of you the way you want to be taken care of. And then you need to make the appointment and go in, fill out the paperwork, and execute your documents. Everyone says, I'll get to it, I'll get to it, I'll get around to it, I'll get around to it. Unfortunately, life happens. COVID happens, accidents happen, strokes happen, things happen, life happens. And to say you're going to get around to it is just not responsible. You're not doing it only for yourself, but you're doing it for your family so that you don't put them through the heartache, the pain, the cost, and everything else of having to go in and obtain judicial oversight in order to handle all of your affairs for you. So call an estate planning attorney, determine who you're going to ask to be your agent, talk to the person you want to be your agent, go in and fill out your forms and execute your documents. That's what you do now. Okay, so now I'm going to stop sharing the screen and I'm going to go and see if we have any questions. Okay, so I don't see any questions oh, here we go. Can you use online forms? Yes, you can use online forms. However, the problem with online forms, if they're not properly executed as specified by law, meaning that they have the proper witnesses, the the notarization, and handled appropriately, then they're no more effective than the paper that they're written on. They could be used for flyers. They mean nothing. In addition, when you go to an estate planning professional who does this, who works in this field every day, for powers of attorney for property, there are additional powers that should be enumerated on your powers of attorney to ensure that your agent has all of the authority to act for you in every way that could possibly come up. The online forms that you get have a one-page list of general topics that it covers. But in practice, it doesn't go deep enough in that let's say that you were in an accident and they needed to sell your car in order to pay for healthcare. A power of attorney that you would get offline, and even if it's executed properly, would not allow that in any way, shape, or form. And if you're not able to speak for yourself, then it wouldn't happen, and you would not have that asset to pay for your care. In addition, as you get older, there are other things that come into play that are not listed. So if you go online to, in the state of Illinois, and you pull up the online powers of attorney for property, those documents are 7 pages long. My power of attorney for property, based on my 15 years of working in this area, has an additional 9 pages of additional powers that include from being able to access your electronic information, to being able to sell your car, to being able to obtain a loan for you, to being able to do all of the things and handle your estate planning documents should the laws change. All of the things that I found in the last 15 years that the simple statutory powers of attorney online don't cover, and would cause you to have to go to probate court to get guardianship in order to get the things that you're looking to do. So the simple answer is yes. The hard answer is it's not advised. Okay, so the next question is, if my adult child goes to college in another state, which state do you execute the documents in? Well, that's a good question. I have always had my clients execute the documents in the home state, because if there is an incident outside of the state, most states, and I literally, I think we're down to maybe 2 states that will not honor other states' powers of attorney. It will cross state lines. Now, the reasons that I say that you would want to do them in your home state of Illinois is that once you're able to get that child home, you're going to bring them back to Illinois, and you want your powers of attorney to be in full force and effect in the state of Illinois. And therefore, that is my recommendation, that you do them in the state in which you live. Okay, so what if I bring my adult child in to get health or mental health POA, and then they decide to name a girlfriend or boyfriend or aunt and uncle? Okay, so you cannot dictate who your child is going to name as their agent, okay? Any attorney, a state planning attorney that's worth their salt, is going to have a very extensive conversation with that child. And they're going to strongly suggest that they not name a boyfriend or girlfriend. A family member, I would not argue against if they felt strongly about it. I would not try to direct them to ensure that the mom and dad were the agents named. That has to be something that that child feels comfortable with, but it has to also be someone that they trust. But life happens, as we've talked about all night, and a boyfriend and girlfriend at a young adult's age is not something that I would be confident in making sure that they were named as their agent, and I would strongly advise against that to the child. Okay. So, well, that looks like all the questions I have. Unless anybody else has got another question, don't hesitate to type it into the chat section, and I'd be happy to answer it. Okay. Who initiates the action for POA? The principal, the person who is covered by the power of attorney is called a principal in legal terms, and the principal initiates that action. Now, when you say initiates the action of creating the POA, that's what I mean. If you mean initiating the action for the POA, if I can't speak for myself, your agent would go into whatever facility, whether it be medical, healthcare, or mental health, or whether it be financial, and provide a copy of the power of attorney for whatever it is that they're doing to the facility, and tell them that they were your agent and that they needed to act. Again, that is the reason that I mentioned before, that you should always give your powers of attorney to your financial planner, to your bank. Keep, as far as healthcare is concerned, keep a copy in your glove box. Give one to your primary care physician or attending physician. And if you go to a local hospital, your local hospital. And make sure that your agent has a copy. The original, again, should be kept in a safe, waterproof, fireproof location, and your agent should know where it's at. You know, one thing that we didn't talk about, and I feel bad that I forgot about it, but not only do you name an initial agent, but you should also name a successor agent. It has happened, and of course right now I don't know if it would happen in this instance because travel is so limited, but it has happened in my life where an agent has been named, and they've gone out of the country, and then their principal has had an incident and there's no one to act for them unless they have a successor agent named. If there's a second person named as the successor to the first person, then in the event that the first person is unable or cannot act, then the second person is able to act on your behalf. So if you did have a successor agent, you would want to also make them aware of, giving them a copy and make them aware of where they could find the original if need be. And also make them understand very clearly that they would never act until the first agent was unable to. So, okay. The next question is, can I change my mind of who my agent is after I execute the POA? Yes, you can change it at any time. And you can change it right up to the last breath that you take in your life. All you need to do is say that I don't want this person to be my agent any longer. Now, you do have an obligation if you've given the copies of the powers of attorney to financial institution or to healthcare professionals. You do have an obligation to inform them that you're removing this agent, because as a third party and you have put this agent out as being your agent and they've relied upon it, they are not held liable if they continue to rely upon it if they're unaware that you've removed or revoked that power of attorney. But you can change your mind at any time. Now, let's talk about that for a minute in regards to cost, okay? Law firms do it differently. At our law firm, we charge a set fee for the 3 powers of attorney, and we strongly recommend that there be an initial power of attorney and a successor power of attorney. We execute them, and if in the first 6 months you want to change your agent, we will change it for free. Okay. Now, thereafter, you would then have to implement or execute, complete new documents, and there would be a cost. We don't, from day 1 to 6 months, again, we change it for free. From 6 months on, for a period of a year and a half, if you change it, we charge a reduced fee. Thereafter, it's the full fee. But yes, you can change the mind of your mind as to who the agent is at any time. And don't forget that as long as you're able to convey and have the capacity to make decisions for yourself, your agent can't make any decisions for you. Now, let's see. You said an agent has to be willing to be your advocate, but what if someone else strongly fights against what my agent is saying is in my best interest? Can they be brought to court? They can be brought into court. However, one of the reasons that I express to my clients the importance of them personally conveying to their health professionals, mental health professionals, and financial professionals that this is who they've selected as their agent, is that in instances like this, when somebody wants to fight against it, then you have a history of you as the principal going out and purporting to the world that these are your wishes and your desires, and you bring that into court first day, and it will be dropped immediately. They will not move forward with the contesting of it just because someone is not happy with the decisions that you've made in regards to your life and how you want it handled. So, so typically what's the cost? Well, I don't know if I can tell you the cost. I don't know if I can tell you the cost of the powers of attorney. Powers of attorney, those 3 powers of attorney at our law firm are under $1,500 for the 3 of them. I hope that's okay to answer, but yeah, under $1,500 to execute all 3 of them. Okay, is there any other questions? We've got about 10 minutes left, folks. I want to make sure you get your money's worth. Is there a fee for the information? Oh, well, at our firm, no. We do have an initial free consultation. It's a 30-minute consultation. Other places charge. I don't know what they charge. I've never charged in my 15 years for the initial consultation to go over the estate planning documents and the importance of them, which of course includes the powers of attorney. Okay. Well, folks, I hope that the information that I've shared with you tonight has been beneficial. I hope that you have found it interesting. And I'm going to share my screen one more time. I'm going to give you my, oh, here it is. I'm going to give you my information real quick. Oh. As I said, oh, I am with Piercey and Associates. We have 2 offices, one in Oak Brook and another office in Barrington. The Barrington office has been there for about 12 years, and I've been open in Oak Brook for about 1.5 years. And there's my address, phone number, and email. And if you want to reach out and you've got some more questions, I'd be happy to take the time to talk with you. But thank you all for joining us tonight. Thank you for participating. Those were great questions. And I hope you found this to be interesting. Okay, thank you so much, and you all have a wonderful night. Oh, I just wanted to mention real quick, the library will be holding this recording of this session on their website, and you will be able to access it in the future if you'd like. Oh, wait, somebody says one more question. Is putting a trust in place a service you provide? Yes. And in fact, that's a very important piece of an estate planning plan and document. And what is the additional cost on top of the POAs? Okay, so once you start looking at an entire estate plan, the cost is going to range at our law firm, depending on whether it's an individual, a married couple, and their assets and their situation. Second marriage, blended families, minor children, all kinds of questions like that. And the range for the trusts are from $3,000 up to $8,000, or I shouldn't say the trust, the estate plans are from $3,000 to $8,000 for a family type estate planning package put together. And again, it's very specific to each person and the individual's actual situation. So that is something that could be discussed during an initial consultation as well. Okay. Okay, so the program is recorded and can be viewed through the calendar at gepl.org. It'll be available in the next few days. Okay, so if you know anybody who wasn't here tonight and they want to hear this information, please have them log on and get the recording and see what they think. Okay. Well, thank you all for attending. And I'd like to thank Beth for inviting me. And I'd be happy to come back anytime. You take care, folks, and God bless you.